The members, and I'll call to order the meeting of the Committee on Members' Interests. It's time and we have a quorum. Item 1 on the agenda. Proposed amendments to Rule 83, Bracket 5 of the Rules of Procedure. But before I go to that, perhaps I should mention this. Now today, there are 3 items on the agenda. The first one I just mentioned. The second one is about proposals on registration of members' interests. And the third one is sponsored overseas visits made by members. Now for the third item on the agenda, we will invite other members who wish to join our discussion to join us. So, of course, this is an open meeting. For items 1 and 2, non-committee members cannot take part in the discussion. But for item 3, other non-committee members could also join in the discussion. I just want to let you know that. And of course, the public always welcome to observe our meeting. Now, first item, as I mentioned, is proposed amendments to Rule 83(5) of the Rules of Procedure. You know why we have this item for discussion from reading the paper. It's paper number CMI 7/13-14. In July 2012, the Companies Ordinance Companies Bill was passed, actually, and there are some amendments to the existing Companies Ordinance. So for certain provisions in relation to the registration of members' interests, that is Rule 83(5) of the Rules of Procedure, this rule will be rendered inoperable because of the amendments to the Companies Ordinance, because the relevant section of the Companies Ordinance will no longer exist in the new legislation. That's why there is an urgency to make amendments to the relevant rule. Of course, you have read the paper. You know what the amendments are. Perhaps I could ask the Secretary to take us through the paper briefly, and then I'll see if members have any comments on the paper. Clerk, please. Thank you. Rule 83(5) of the Rules of Procedure provides for the registration for the 8 categories of interests that are required to be registered by members. 83(5)(a) remunerated directorships of companies and shares. Now, because of the commencement of companies bill, then this rule will be affected because of the changes to the companies bill, and therefore remunerated directorships of companies, public or private, and also the name of the subsidiary of the company. That's what is in Rule 83(5)(a). And then in Section 2(4) of the Companies Ordinance, there is a definition for subsidiary. And then with the definition of subsidiary company, then there will be definition for holding company. Well, in the new ordinance, in Section 13, first there is 15. There is a definition of holding company, and then using this provision, there is a definition for subsidiary company. So the construction is different, but actually the substantial meaning of the 2 terms is not changed. The relevant provisions are in Appendix 1. For Rule 83(5)(a), there's mention of subsidiary. And so in paragraph 7, we propose to amend 83(5)(a). So the reference to subsidiaries is replaced by a reference to holding company. And the other section that we affected is about shares. Rule 83(5)(h). The threshold for registrable interest of shareholdings is now 1% of the issued share capital. And in the new Section 135 of the new Companies Ordinance, there will be mandatory no par value for shares, company shares. But then in Rule 83.5H, there is mention of nominal value, and this will no longer be operable in future. So that's why in paragraph 9, the Secretary proposes to change the wordings for threshold of 1/100th of issued shares. We change that to shares of a number greater than 1/100th of the total number of issued shares. Now, if members agree to the amendments, we will refer these amendments to the Committee on Rules of Procedure. We'll consult them, and if subject to the CROP's views, CMI will then seek the views of the House Committee, and the motion will be moved by our chairman to make the amendments. Now, for the commencement of the new companies ordinance, it will be the 3rd of March 2014. So there is a time limit for us to move the motion within this time frame. Thank you, Clerk, for your brief introduction of the paper. Shall we do this? First, paragraph 7 of the bill. That is about Rule 83.5A. And then we'll move on to the next one, Rule 83.5H. As the clerk mentioned, there is no change really. It's still the same company. In the past, we used the reference of subsidiary company, but now we follow what's to be in the new companies ordinance, and there will be a reference to holding company instead. Well, the companies ordinance is a bulky one, as you know. In the last term of the council, members spent a lot of time to consider the amendments to the company's ordinance. The legal advisor was also in charge of the company's bill in the last term, so he knows the provisions very well. So what do you think, members? We just follow the reference to the company's ordinance. Well, we have no choice. We have to follow the company's ordinance anyway. So any views, please, members? Mr. Chairman, I think what is important is clarity. If there is such a legal provision, yes, of course we have to do something here. Holding company, is it all the way to the top? Because, you know, there are some companies, if someone are directors of a particular company, above the company there may be another controlling company. Is parent company or grandparent company and all the way, you know, will it go all the way to the top or up to what level? My understanding is it will go all the way up to the top. Legal advisor, please. Or is the new ordinance not yet commenced? Can you speak into the microphone, please, legal advisor? It's something so complex. Please, thank you. Now, in other common law jurisdictions with similar legislation, it's considered that the connection is all the way to the top. It's not just a single level of connection. And here, the requirement is not about just any holding of shares. It has to exceed a certain percentage. You mean 50%? Yes. Yes, Mr. Jeffrey Lam. If there are several levels, what do you do with the levels in between? If my understanding is correct, in principle, it should be disclosed because it goes all the way up to the top. Well, I really do not understand the company's ordinance. What do you mean there are several levels? Well, let's say there's company A is a parent company of company B, and then under company B, it's possible that there are 2 or 3 more layers of companies. Let's say it gets all the way to company E, you know, and several levels down, that is. but the person's duties have only to do with company E. It has nothing to do with companies A, B, C, or D. But yes, there is some form of connection, indirect or direct. And company A is the ultimate holding company. If there is need to declare, every company, we have to make that clear to our colleagues. And in terms of business, it's possible for companies B, C, D, their business has nothing to do with company E at all. And then how do we declare the business then? Because it's not just about declaring the connection, right? And it's possible there could be conflict of interest involved. That it's possible that certain business of one of the companies may have conflict of interest with a business we deal with in the Legislative Council. Do you follow what I'm saying, Legal Advisor? Well, as long as he follows, then it's fine. Legal Advisor, please. So my understanding is, along this chain of companies, there are very many different companies involved in different types of business. And then the different companies may therefore have some form of connection with the business of the relevant legislative members, relevant legislative member concerned. Now, my understanding is if there is need to make a declaration, is the declaration about the related companies. In other words, the declaration is about the connection of each company to the business of the legislative member concerned. It's possible that among companies or between companies, there's just a connection by way of shares, but there is no connection whatsoever in the business nature. And for directors of company E, it's possible they do not know what companies A, B, C, or D are doing. But then in the business this council deals with, it's possible that there could be discussion of certain items that are related to companies B, C, D. In that case, would it become a case of failure to disclose? Maybe the member doesn't even know that he ought to declare it. The member may not know. But there is some form of connection there. Legal Advisor. Or if the member honestly does not know, of course he cannot make a declaration. And my understanding is members ought to declare what they know. But then if they do not know, well, then it depends if it's because they haven't exercised due diligence to check if there is any business connection, or in normal and reasonable circumstances, there is no way he could find out. So it really depends on the case, the facts of the case. In principle, if the member knows, then he must declare. But if he does not know, and it's not because he deliberately tries not to find out, or it's not negligence, or he just doesn't care, he just turns a blind eye to it. If it's not like that, then there shouldn't be any legal liabilities. That's all I could say.
But what you said might be different from the analysis of some past incidents. You talked about due diligence and conducting checks. Well, we deliberate on various topics in the council. something might pop up all of a sudden. So the principle is that as long as the member genuinely does not know, then subsequently, if it's found that the member actually knew, then that's another matter. But we need to be very careful if the paper is proposing some recommendations based on changes made to the new companies ordinance, and we are making some changes accordingly. I just want to make things clear. I think the clerk would like to supplement, but I wish to remind members that the proposed amendments have to do with the new companies ordinance, so that our rules of procedure can be aligned with the new companies ordinance. And Mr. Lam made a very good point. Our next item may also be related to the issue in question. Secretary General. Chairman, you are right in pointing out that this paper doesn't change the principle of registration of interest. And Mr. Jeffrey Lam might be referring to disclosure, which is another matter. Ms. Lau. Well, I am reading this part. If it's registrable, that means it should be declared. The next step is to see what should be done if it's registrable. During the fourth term of LegCo, we had a similar discussion. So we're coming back to the same topic. We are revising the form in accordance with the new companies ordinance, and whether the reference made should be changed. This is the perspective that we are taking. In the past, reference was made to a subsidiary company, but now the reference is a holding company. So I will seek views further from members. Well, Chairman, of course, Mr. Lam is saying that as long as it's in the provision, we should follow the provision. I also agree, but I think as far as the guidelines are concerned, the members should be made clear how the registration is to be done. Mr. Frankie Yick, if you say that we are going to have another discussion on the declaration, then I'll wait, because I'd also like to ask about that situation. So let's wait for the next item. So do members accept the proposal? We have no alternative but to accept. So otherwise, what alternatives do we have if we don't accept? All right, so paragraph 9. Along the same line, under the new companies ordinance, the reference to nominal value has been deleted. And we have prepared the relevant amendments to change the references to nominal value and issued share capital to the number of shares. So that now the existing rule, which makes reference to the percentage of the issued share capital, is no longer valid. Any questions to the change? The reference is no longer accurate. No problem. No questions. So, members are invited to consider whether you agree with this decision, so that the matter will be referred to the Committee on Rules of Procedure. They will be consulted, and the House Committee will also be consulted. Subject to the views of these two committees, should they agree, then as chairman of this committee, I'm going to move a motion at the council meeting to amend the relevant rules in the rules of procedure. That's the steps to be followed. Before the 3rd of March next year, that is before the new companies ordinance commences, we need to have this done. Any questions? No? Then so much for this item. Next item. Proposed amendments to the requirements for registration of members' interests. Now, in the fourth term of the Legislative Council, during the last session, in relation to the registration form, a survey was conducted, and the outcome is set out in the paper. Since it was the end of the term, we had not implemented the relevant changes, and now we're in a new term, so it's time for us to revisit this issue. And would the clerk please take us through the paper? Thank you, Chairman. The paper is paper number CMI/8/1314. The Committee on Members' Interests of the Fourth Legislative Council, in the beginning of 2012, reviewed the requirements for members to register their interests, having drawn reference from the House of Commons in the UK Parliament, the Executive Council, and the Legislative Council. In relation to the registration of interest by members, the CMI proposed that following changes be made to the registration requirements to enhance transparency and accountability. The requirements the major difference on the requirements among the three bodies are set out in appendices 1 and 2. And paragraph 4 to 6 set out the changes proposed. In relation to directorships, remunerated employment offices, and clients, members are required to register the nature of work. That's in 4A. And then in 4B, under overseas visits, members are required to register the estimated amount or value of the sponsorship received by members or their spouses arising out of the membership of the Council. 4C, under land and property, the usage and location of the land or property owned by members should come with greater details. 4D. Now, in relation to remunerated membership of boards, committees, or other organizations, the change should also be the change in shares should also be the dates of changes should also be registered so as to enable the public to monitor whether the particulars have been furnished within 14 days of any change. And the form should be incorporated in the new schedule to the rules of procedure, so that apart from complying with Rule 83(5), they need to provide the particulars as required. The proposed form is in Appendix 5. The CMI of the 4th LegCo had consulted members on the proposed changes by way of a questionnaire. The consultation outcome and the details in the summary are in Appendices 3 and 4 respectively. The 4th term LegCo's CMI supported the views of the proposed amendments, and the House Committee agreed that the chairman of the CMI should move a motion at the council meeting. The motion was put on the agenda of the last council meeting, but was not reached before the 4 LegCo stood paroled. Thank you. Thank you, Clark, for your introduction. Mr. Frankie Yik, so coming back to you, this issue concerns what you have raised. Now, it concerns a very complex structure. For example, a company has appointed me to become a director. That company might be running a business of a restaurant, and then there are different tiers, and then the top at the top it might be a general enterprise, and then I might be asked to list out all the connections. But sometimes I might not be involved in the business, and I might forget to declare my interest during any debate in the council, and it is risky. I don't know how many types of business that company is involved, and I may be just a director of a restaurant. So I'm exposed to huge risks because I am just a director of a restaurant, and they may not tell you the whole structure of the corporation. So in terms of declaring interest, I am really worried. I may not be aware of other matters, and then I might be accused of pretending to be ignorant, since it was gone through during the last term. So what if there is still a holding company or a parent company on top of the company appointing you as director? Then should you only declare your directorship of your own company, or should it be the case that since the scope of business of the parent company is so wide, will you be affected? Should we maintain the present arrangement? Will problems, as mentioned by Mr. Frankie Yik, arise so that the declaration or registration of interest is not accurate? On declaration, the member can only declare the interest to his knowledge. So you can't answer it right. It is a very simple question raised by Mr. Yik. Well, a member might query you for not knowing about it. Well, yes, you might be in the catering industry, and then we have the legal advisor here. Sorry, Chairman. Like SG said, maybe the focus is on 83A. The paper today deals with registration. Now we are focusing on remunerated directorship. So the fact that it's remunerated must be known. And our proposal in relation to the form is in 4A. That is to have an additional requirement in relation to remunerated directorships and clients, etc. The nature of work should be declared. As for parent company or subsidiary company or the so-called holding company under the new companies ordinance, no change has been introduced yet in relation to the connection. As to whether it should go all the way up, then it's still subject to the rules of procedure. In the form, it's quite clearly set out that if you are the remunerated director of a certain company, if the company is, according to the existing companies ordinance, a subsidiary of another company, then the name of that company or the name of that the other company. That means one layer up. But now the definition will be changed. So that depends on, say, in the future, whether you own more than 50% of the shares or whether you have the power to appoint directors. So coming back to Mr. Yik's question, if he has no decision-making powers or he is not at the topmost layer of the company, maybe he is just a remunerated director of a company in between, and under that company there might be other subsidiary companies. And as far as his company is concerned, he doesn't have any power to influence the parent company. Chairman, this is correct. So in paragraph 7, we are proposing, as regards the proposed changes, something stands to be corrected, and that is in paragraph 7. As long as it's changed from subsidiary company to holding company, then which paragraph 7 are you referring to? The last paper we discussed, paragraph 7, I'm sorry. So regarding the declaration, it's downward instead of upward. I need to declare before we continue with the discussion. I am the director of some companies, some public listed companies and private companies. So when we are discussing about remunerated directors, I think I need to declare the interest. Of course, I need to declare as well. I don't think so, because it has to do with the policy in general. But I won't object if you wish to declare. Mr. Yik, is that explanation clear enough? Now, it should be clear by now that we're referring to companies below. That is, subsidiary companies that you have the duties to have knowledge of, whereas for the companies above, you don't have any powers to influence the company.
SG? The legal advisor referred to paragraph 7. Now, I'd like to find out myself too. Remunerated directorships of companies, public or private. And if the company concerned has a holding company, right? Holding company. So is it upwards or downwards, legal advisor? What do you mean? Definitely that's upwards. What I'd like to clarify is this. Sorry, speaker's off mic. Speaker's not coming through. Now, we just need to amend the reference to the original company. And also, the subsidiary company should be changed to a holding company, that's all. So it should read like this. If the company concerned is the holding company of another company within the meaning of Section 13 of the Companies Ordinance, also the name of that other company. In other words, it should the amendment will be to change the original intention. Now, if we follow the wordings in the current paragraph 7, the declaration would be about companies upward. But actually, we meant it to be about companies at the lower levels. That is, only for a subsidiary company there is a need to declare, but there's no need to declare another company further up. That is the holding company. So there's a change of the intention then. Well, paragraph 7, the way this worded now, it's at odds with our original intention. So the changes we need now is that for the reference to subsidiary and to companies ordinance, we just need to change it to holding company. That's enough to reflect the original intention of the clause. Now, in paragraph 7, we did not notice this change arising from the proposed wording, so we do apologize. What do you mean now? I'm confused now. Paragraph 7, does it refer to a company further up the hierarchy or down? Well, in the existing paragraph, is a company further up, but that's not our intention. So you mean you have to change it? Yes, that's right. Just now I read out the new wordings to members. Secretary, Clerk. Members, yes, Mr. Chairman, if I may refer you to the blue version, the original version, and then we will better understand what we're talking about. First page, remunerated directorships. That is Appendix 1, the blue book, the form. It's best to look at the registration form, directorships. Now what we need to register is remunerated directorships. It says here, if the company concerned is a subsidiary of another company, please provide the name of the other company. This bit is clear. So if you are the remunerated director of company A, then you have to register the parent company of A. That's what it means here. And then paragraph 7 of the paper is just put the other way. That's all it is. That is, if you register the remunerated directorship and the company has a parent company called holding company, please also register the parent company. That's also, the meaning is the same. In other words, if you are the son of a certain person, now you must register the name of the mother. So now in paragraph 7, that it just says that if you have a mother, just register your mother. It just put in a more direct way, that's all. Okay, now I follow. So here it's just talking about one level up. But then the company's ordinance, it says, CMI 7, 1314, paragraph 4. Company A is a subsidiary of Company C, which in turn is a subsidiary of Company B, and you have to register it. So it seems that as long as one level controls a lower level, that is, then you have to declare all these other companies. Is that correct? But it could be a mammoth task. It could involve a lot of companies then. Now in Appendix 1, current law does provide for that already. There is this extension already. In other words, if you are there is some subsidiary company, then the parent company or the grandparent company also has this subsidiary relationship. You have to declare it as well. That's already the existing arrangement. Just that in future the law will be written the other way round. So, but still the relationship between the subsidiaries and the parent companies remain. So, in accordance with the existing requirement for companies B, C, there is still this subsidiary and parent company relationship, although it's several levels down, and you must still declare it. Well, I'd like to thank the clerk for the clarification. Oh, so actually under the existing form for registrable interest, 1, directorships. Apart from declaring subsidiary companies, you also have to declare the parent company. You just have to give the name of the parent company. You have to go all the way up. And then Mr. Jeffrey Lam mentioned a case. It may be a company in the middle, and they maybe there are 2 other companies further up before we reach the top company. So do we have to declare the 1 level up, 2 levels up, or just the top level up? I think we have to make that clear for members. Let's say there are 3 levels in between, and these companies may have no connection to Company E in terms of business nature, and you wouldn't know what these other companies do. So, legal advisor, how do we register interest then? Okay, we know Now there's actually no change to the original requirement, but it's just brought out a new question. That is, how should we register interest so that we won't breach any requirement? Now, let's take the existing form. You only need to provide the name of the other company. There is no need to provide other information. Well, it's fine, with the information, but what about the two levels in between? We quoted an example. A is at the very top, and then there's B, there's C, D, and now Mr. Jeffrey Lam say he's the director of E. So for B and C, do we need to register the other two companies, or do we just declare A? Now, if it's in line with the definition of holding company, then there is need to declare it. Secretary General? It's exactly it. If we, you say if it's in line with the definition of holding company, then what exactly is the definition? Because that means the holding company can control the acts of the subsidiary company. That's my understanding of the definition of holding company. And of course, members may think that from the subsidiary company's point of view, there's no way it can, in return, control the parent company. But, the purpose of the registrable interest is to see which companies could control the company which appoints the member as a director. So I would ask members to look at it from another angle. We're talking about controlling interest. As mentioned in the paper, it has to be more than 50% control. Mr. Yik, if you look at the original form, I think when any member fills in the form, he would say, okay, I have to report the company one level up, so I will do that. But I don't think anyone would refer to Cap 32, the company's ordinance, to say, oh, so in the original section, it says that you have to go further up all the way, as long as there are other holding companies, and many people could be caught, because say I'm the remunerated director of company E, and there's D holding E, so I report D as well. But I wouldn't know. I actually have to report A as well. But if I had studied Cap 32 in detail, that's what I need to do. Well, yes, from the wordings, this could be the case, but I don't know what members' exact understanding is, because the management of the register is with the clerk, so he would know better. But I think the last understanding we were talking about was what I understand about the meaning of the company's ordinance. Whether it's a subsidiary company or holding company, it's the same kind of relationship. If you know business well, you know what it is. Sometimes it's just de facto arrangement. It's not through shareholding, and the facts would only be known to the relevant members. And the Secretary General has pointed out the crux of the matter. Now, of course, the starting point is which company gives you remuneration. But if can this company control other companies? Well, I think that's what the public would like to know. It's not about. It's about the level of transparency that we all accept when members exercise their perform the duties as members of this council. Okay, now so we've discussed that, but I think the important point under discussion is whether we follow what was agreed in the fourth term of the council. So what is the direction to take, members? How are we going to follow up on what's left to be dealt with from the fourth term of the council? That is the amendments proposed. Now, my personal view, can I suggest this? This is new term of the council, so perhaps we will again do a questionnaire to all members, parties, and groups and then we ask members to give their views on the amendments proposed by the fourth term of the council, and then when we have collected all the views, then we will decide what we do. Do you agree? That is, we'll see whether members agree we should still adopt the same proposed amendments or not. So, members, shall we deal with that as I just suggested? Mr. Emily LAU. I have no objection to consult because we do have new members. Of course, we did a consultation last term, and as another member pointed out, it was only because it was stalled. But I think the Secretary has to make things very clear, because just now we already had a lengthy discussion. We have to tell members whether there are options, and if there are real options. If the Secretary General and the legal advisor both believe that there is much room, you could declare a lot or you could declare very little. But it depends on the requirements, because it's in the rules of procedure. I think, but we need to make that very clear. Otherwise, people wouldn't know what you're consulting them about. Do you follow me, Clark? SG, you don't just ask members to take options 1 or 2. You have to explain things to them, because other members not here. So you have to explain things clearly to them. Do we really have a lot of scope for members to opt how to disclose or register interest? You have to tell them if that's the case.
SG, according to the present registration requirement, I would say that there is much room here. As said by legal advisor just now, there may be de facto connections which only the persons involved would know. And as we draft the guidelines, we have set out the principles. For example, whether a company is holding another company or having control over another company. And shareholding is one of the ways to control a company. There could be other ways to control a company. And this document in front of us also set out some principles. The purpose is for the public to monitor the members' exercising of their powers. Some background information should also be made accessible by the public. That's how I would describe it. As for the requirements, or whether there should be additional requirements, it's exactly what this paper is about. We'd like to seek views from members. I understand, Chairman. I think SG understands what I am talking about. I'm just saying that when you prepare the questionnaire, please explain in greater detail, or the members might not know how to make their choice. In Appendix 4, where in Appendix 4? Appendix 4 of this paper. Which paper, Chairman? Paper 8? Has proposed amendments to the requirements for registration of members' interests. Appendix 4 sets out the questionnaire conducted during the fourth term of LegCo and the members' opinion. I don't agree that there is a majority of members agreeing to the proposal. I think the views are split. So this information will be provided to all members regarding our discussion during the fourth term, and then we will conduct a questionnaire survey similar to the one conducted in the fourth term, and to further consult members on their views before we discuss at this committee again. that's what I'm minded to do. The views expressed during the fourth term LegCo must be made known to the incumbent members, and their responses should be sought before we discuss the proposed amendments. As to whether amendments should be made, we need to wait for members' responses first. Mr. Jeffrey Lam. Now, as Ms. Lau put it just now, if you just sent out the questionnaire, perhaps members wouldn't understand. We discussed for a long time, and we raised some questions in relation to the registration, and some questions are left unanswered. If we just send out a questionnaire to members, some members might not even know what questions they are actually answering. I think there is a need to explain in greater detail to members. We must not assume that members understand. So perhaps the Secretariat can arrange for a briefing session before we distribute questionnaires. Secretary General. Thank you, Chairman. Now, I understand that during the last term, before the consultation was conducted, we also held a similar briefing. So, like the last time, we can conduct a similar briefing as for the benefit of new members. All right, so we can invite members to attend the briefing and familiarize with the topic before we seek views from them, and then we can come back to this topic later. So, this is the way forward for us. All right. So much for the discussion of this item. We will proceed with what's been said just now as soon as possible, a briefing session followed by questionnaires to be distributed at the appropriate time. So, item 3 on the agenda, sponsored overseas visits made by members. All other members are invited to join the discussion of this item. We have sent invitations. I understand that some members indicated their wish to attend, but they haven't shown up. The meeting is scheduled to end, or the item is scheduled to begin at 5:45, but we're not going to wait because I understand that the members of this committee will need to leave before 6. Mr. Gary Fan. Now, the item is about members accepting the invitation of an airliner to receive an aircraft on a trip in August. And in accordance with the requirements under the rules of procedure, they have made a relevant declaration. However, this incident sparked debate in the community, and we received submissions from some members asking for a discussion on this topic at this committee, including Ms. Emily LAU and also Dr. Kenneth LEUNG, who is not a member of this committee. The Secretariat on this matter prepared an information note on mechanisms governing sponsored visits and travel in Hong Kong and selected overseas places. That's in relation to parliaments or councils in other places. The information note has been circulated to members, and I'd like to invite the personnel of the research office to take us through this information note. before we start our discussion. Thank you, Chairman. Well, earlier there are public concerns over the sponsored visits being accepted by members, whether it was appropriate, and we have been asked to prepare some information to facilitate deliberations of this committee. And therefore, we prepared an information note on the arrangements for electoral members, members of EXCO, and political appointed officials of Hong Kong SAR, together with the relevant requirements. That's in relation to regulation of sponsored travel undertaken by Parliament members in countries like UK, Canada, Australia, and US, etc. And let's look at Hong Kong. Both LegCo and EXCO members are required to register their sponsored visits so that the public can check whether the sponsored visits accepted by them are subject to any conflicts of interest. And within 14 days after the trip, they are required to register the basic trip information, such as dates and purposes of visits. And there are procedures governing the investigation of complaints against non-compliance, and non-compliant cases or members may be sanctioned. For principal officials, they are required to seek permission from the chief executive before departure, and they need to provide basic trip information as well as reasons for accepting the sponsored visit. And the non-compliant PAOs may be sanctioned following investigation of complaints. For selected overseas, the information I mentioned is set out in the table. For overseas places, they also have registration of members' interest for public to check whether they are discharging their public duties with any conflict of interest. In UK, Canada, Australia, and New Zealand, sponsored travel is regarded as a registrable interest. In UK, Canada, and Australia, if the cost of travel exceeds a certain monetary sum, they are required to register within a month or two after the end of the trip. In New Zealand, the members are required to register all sponsored overseas travel. However, they only need to submit an annual return on their sponsored travel made in the previous 12 months. And for sponsored travel, the members are required to provide basic trip information. And there are also procedures to deal with non-compliance, and non-compliant members may be sanctioned. The mechanism adopted for the U.S. is different from the places mentioned because the House of Representatives has put in place specific rules, namely the travel regulations, to govern members' acceptance of sponsored travel. In 2007, this set of rules was enacted, and earlier, before 2007, there were rules governing this matter, but before 2007, there were congressional staff, and members and officials illegally accepting gifts and travels, and the public was outraged, and so the Committee on Ethics amended the House rules, and then regulations were enacted to establish a process for approving members' requests for undertaking sponsored travel. At least 30 days before departure, members are required to seek pre-approval for their sponsored travel from the Committee on Ethics, and they are required to submit their basic trip information along with the application and explain why the trip is connected with their official duties. And they are required, the sponsors are required to complete a trip sponsor form to provide basic trip information and a detailed program of activities to be attended by the member during the trip, including the transport arrangements, etc. Assessment will be made by the Committee on Ethics. They will consider, for example, whether the sponsored travel relates to duties of members and whether it is in compliance with the restrictions on duration and location of the trip before deciding whether the sponsored travel will be approved. On conclusion of the trip, the members are required to submit a post-travel disclosure form to the clerk to disclose the relevant information to the public. For members participating in trips without pre-approval from the committee, the members are required to repay the sponsors all expenses incurred during the trips. And there are also procedures governing non-compliance, and non-compliant members may be sanctioned. The details are set out in Table 2. So much for my presentation, Chairman. So members can see that there are various requirements in various places, but the major principle is that it should be subject to public scrutiny, including UK, Canada, Australia, and New Zealand. They must be registered so that the public will know whether such act would cause a conflict of interest or potential conflict of interest when the member discharges his duties. The other mechanism is the US model, and that is the monitoring will be done by the House of Representatives, and they have a committee on ethics, which is responsible for approving applications. Approval must be sought before you can accept the invitation. Now, about the composition of the Committee on Ethics, can you give me some information? 10 members, 5 from Republican and 5 from the Democratic Party. And usually the majority, the member from the majority party will become chairman. And for sponsored travels, office member on the Committee on Ethics will check all the information contained in the application, and if all the requirements are met, then the application will be forwarded to the chairman and also the minority member to vet the applications together. So what is the role of other members in the committee? The staff or the office bearer of the committee is tasked with important responsibilities. He is required to check all the information, and he may be required to ask for further information, and then an advice would be given to the chairman of the Committee on Ethics and see whether all the information has been provided before the chairman decides together with the minority member whether to approve the application. Basically, the staff will ask the member and the sponsor for information and see if all the requirements have been met. If all the requirements have been met, then in principle the application should be approved. You haven't answered my question. What about non-compliance? Over the past 4 years, 88 to 90% of the applications were approved. For applications not approved, the reasons for rejection is not that the committee rejects the application, but that the application must be made 30 days before departure. And the other point is that they have very high requirements on lobbyists. And if the sponsor or the company sponsoring the trip has hired lobbyists, then they will be rejected. All right, so questions from members. This is the information for members' reference. So about this discussion on sponsored over visits made by members, the incident has sparked a request for a review on our existing mechanism. Ms. Emily LAU. Chairman. Well, I wrote a letter and also raised this point in the House Committee. The recent Cathay Pacific incident sparked public views and public concerns. One of the concerns is that it may be an over-generous or luxurious treat because it involved a trip to Europe and also hotel accommodation was provided. But according to the information prepared by Electrical Research Office, there is no requirement or no prohibition on overly generous hospitality treatments. So what are the criteria involved in deciding whether the member should accept the invitation or not? I see this is not one of the considerations. For U.S., the requirement is that it must be made 30 days before departure. For UK and Australia, it can be or declaration or registration can be made after the trip. So the question is whether we agree that this should be set as one of the criteria. The Democratic Party thinks it should be made a criterion, but whether it's overly generous, whether it should be made one of the criteria. I don't think some invitations are controversial. Some for the attendance of some seminars, well, usually it's not controversial unless it's an invitation by a commercial organization. So I'd like to seek members' views on whether we should abide by the strictest standard that is similar to the U.S. We set up a committee, or do we just have a registration system like other countries? In the UK, more information should be provided. And for overly generous hospitality, well, Dr. Kenneth LEUNG has made a suggestion.
As you mentioned him, he's here. Maybe he heard you call him. No, he didn't make a suggestion, perhaps. Anyway, since he's here, he could speak later. And last year, of course, bow tie, sparked another debate. So the public are very concerned about such issues. I think members have to respond in a reasonable manner to the public concern. That is whether we should continue to receive such hospitality. I think we have to discuss the matter very prudently. If we may decide what is overly generous, and we have to decide that is we shouldn't accept overly generous hospitality, then we should say so. Now, some companies like the theme parks. You and I've been to those functions. Now, people are so scared they don't dare invite government officials to meals, and the government officials dare not invite people to meals too. But I think we should be specific. Are we talking about overly generous or lavish hospitality, or could there be a conflict of interest? Because some may say this is a commercial company. If in future in this council we have to deal with business involving the company, then what do we do? And of course, if there are EXCO members present at the sponsored visit, it makes things more complicated. So I'd like to find out what members think. Perhaps under some circumstances that perhaps Electrical believes we ought not accept such sponsorships. Well, you've said a lot, but let's deal with your first question. What do you mean by lavish or extravagant sponsorships? Now, what kind of sponsor visits could be accepted? In the Commonwealth countries, there is no specific provision to prohibit the certain type of sponsorships. Now, page ages 8 to 10, we only see they ask you to provide some information. But for the U.S., there is a detailed regulation on sponsored visits. For instance, transportation arrangement, it has to be the most basic one. Usually they will not allow first-class travel unless there are special reasons, say for security reasons. under normal circumstances, they will not approve first-class travel or private jet travel. What I mean basic transportation. First class, of course, is extravagant. Business class is acceptable, but let's say in some planes there are just two classes, first class or economy, then they will only allow economy. And then accommodation. But what if there's just a business and economy? The most basic transportation, I think they accept a business. They allow business travel, business class travel. But if it's first class travel or private jet travel, it's stated specifically is not permitted. So that's the U.S. case. Well, Ms. Emily LAU asked a lot of questions. What is considered extravagant or generous? I think we have to listen to members' views on that. Perhaps we ought to clarify certain specific issues this time. Maybe it's a judgment about the value. Of course, if a company invites members to such visits, could there be latent interest involved? What about conflict of interest and so on? On generous hospitality, how should we approach it in our discussion? Because you have asked many questions, shall we go through each of the questions, or do we allow members to give their views first before we come back to specific questions? I think perhaps we should allow members to speak first. Who would like to speak? Please raise your hands. Madam Chen Yunhan, Mr. Yu Siu Wing, Dr. Kenneth Leung. Who else, please? Okay, Ms. Chen Yunhan. Mr. Chairman, when this case happened, there was a LegCo group visiting Taiwan and Japan. So there were quite a number of us in the coach, and we had a discussion. We had a rather enthusiastic discussion. Now, many of us were on that bus, and we had a discussion. I think the objective fact is that there's high public expectation of LegCo members because a few officials were found to have acted properly. And so that's why the public have high requirement of their representatives too. So in our discussion, we said perhaps for sponsored overseas visits, we have to approach them really carefully. Now, if other parliaments invite us, that's fine. But if there are commercial companies inviting us, yes, I think we have to think about that carefully. It doesn't matter if it's the EXCO or LegCo. Now, EXCO formulates policy, LegCo scrutinizes this bill, and we are all just human beings as members of the council. So I think we have to be stringent. And by that, I mean we should make declaration. Let's say if Cathay or other commercial companies invite us, at least there should be declaration. There is already declaration. Now, because of this case, the FTU has amended our rules because the FTU has always got strict rules. Spouses, relatives, what about them? We don't see any need. If they invite members, it should just be the members. That's what we require now. So I think we need to lay down a set of guidelines. We need to declare so we can make it known in the public who have invited us. And from my point of view, I would say if there's an invitation of commercial companies, we have to be very careful because we've been through a lot in Hong Kong, and Hong Kong people expect the people's representatives to observe the same standard of behavior as government officials. Otherwise, they might think that we are being stringent with government officials, but being too liberal with ourselves. So what I'm suggesting is whenever there's invitation from a commercial company, they must come back and declare. But there is already a declaration system. Then something must have gone wrong in the declaration form. Otherwise, this case shouldn't have arisen. But there is already a declaration. If you think there's a problem with the declaration system, you have to point out exactly what the problem is. For example, for spouses, well, then if it's that's not about declaration then. If you think that spouses should not receive sponsorships, then that's a separate issue. Now, of course, we are invited on visits. We will inform LESCO, but I'm stressing that for commercial sponsorship, we have to declare. You said there's already the declaration. Well, then I'm saying that we need to include all the details so we know exactly what we need to do. Can we have a discussion on that, please? Mr. Yu Siwing? There are many different forms of study tours. Like I'm from the tourism sector. Sometimes we're invited to go traveling because say my company is in the travel business. Of course, I need to check out travel destinations. For members, of course, they also do study tours. Maybe say like the French trip case, Cathay Pacific invited you to go and check out the new aircraft, or maybe the green angle of the aircraft, how it affects the air quality of the airport and so on. Or, of course, we couldn't rule out the possibility that is just using that as a pretext to treat members to a trip. So what is exactly a study tour and what is just pure hospitality? I think the public will know. And that's why there is a need to give a reason for the visit. Now, I would say the problem here with the declaration system is that for LESCO members, we just need to report the date and the destination. There's no need to give reasons. But for politically appointed officials, they have to give reasons of the visit. I think the public believe that we are being very strict with government officials, but we are being easy with ourselves. So if we have exactly the same declaration system as that for government officials, and there's a basis for public monitoring, then I think we could resolve these sort of problems. So I think we should follow what officials need to do. That is, we give the date, the place, the destination, and the reason. Purpose is in there. No, it's not in this form. No, it's in the form. The purpose of the visit. And the number sponsored. But no, it's not in this table here that I've got. I don't know about IXCO, but I think for LESCO and politically appointed officials, I think we should have exactly the same requirement. So we could monitor the government, and the public will monitor LESCO members, or even government officials will say, well, you say we're doing this, but what about you? You're also doing that. So it's mutual monitoring or check and balance, and there's also monitoring by the public, more importantly. Now, if our form is exactly the same as that for officials, then it's fine. Well, I understand the content of a form is the same as that for IXCO. For IXCO, there's need to seek permission from the chief executive, but we don't need to seek permission. If I may refer you to page 5 of our paper. Table 1, mechanisms governing sponsored overseas visits in Hong Kong. Information required for disclosure. LESCO, information required 4 points. A, dates of visit and also purpose of visit, and then politically appointed reasons. As item C, reasons for accepting the invitation. No. C. No, for LESCO, page 5, table 1. C is only name of sponsors. B is purpose of visit. It's only purpose. There's no reason required. It's a matter of presentation. I mean, it achieves the same purpose. Other views, please. Dr. Kenneth LEUNG. Thank you, Mr. Chairman.
Thank you, Chairman. Before I departed, I made a very detailed declaration in advance. I made a full declaration. That's why the journalists were able to find so many information. The point is, even if you make declaration before departure, even if you perceive that no conflict of interest would be involved, the general public was of the view that was or queried why you would think that there was no conflict of interest. From another perspective, there could be problems if approval is required for trips exceeding a certain sum by a committee. Sometimes some organizations might invite members for a visit. Now, if the applications are not approved by the committee, then there could be arguments. Now, the suggestion in my letter is that we might have adopted a more relaxed approach as far as declaration is concerned. It now is very lax. Registration should be made 14 days after the trip. And as for the amount involved, perhaps a dedicated team or the LegCo Secretariat should check and see if the sponsored amount is overly generous, and then give advice or reminder to the member whether invitation should be accepted. And I think that there is a problem here. The general public might feel that as long as disclosure is made, there is no problem. But some members of the public might think that members should not accept hospitality, which might be conceived as overly generous. But we need to strike a balance here, because we do need to go to duty visits from time to time. Dr. Low Kwok. Chairman, I think ultimately members are accountable to their voters, and I think on this point we all have we need to have our own standards, and that is how we're going to account to the public or to our voters. Some destinations might be very near, but the hospitality might be very generous. And some destinations might be very far away, like and which involves a huge sum or cost. So I don't think we should set a frame. Well, I think the declaration mechanism itself is not the problem, according to what I heard from members just now. Now, about the delivery of an aircraft, I think members should also support it for the purpose of supporting the aviation industry. As to whether the trip is overly generous or lavish, too lavish or not, that's subject to members' own judgment. And I need to declare that I didn't go on this trip, but as an engineer, I had there's all the more the reason for me to accept such invitations. But I will be careful in considering whether to accept such invitations to avoid being questioned by the public about the purpose of visits. If the purpose is really about discharging public duties, then the question is how we can convince the public in accepting our decisions. Mr. Jeffrey Lam, I think it is difficult to stipulate an amount and or impose a cap in deciding whether we should accept invitations or not. For example, for duty visits, for LegCo members, we do have a set of guidelines. We must not accept invitations with accommodation in a 4-star hotel or above. And I had the experience of staying in a very tiny hotel room, and I could not even turn around. And sometimes I need to travel to faraway places for duty visits, and we do have guidelines to follow. As said by Dr. Low Kwok just now, they might need to travel to faraway places. They might need to go to the North Arctic or the Antarctica to see the global learn about global warming. So that depends on the purpose of visit. And some companies in the aviation industries, they may not be airliners, or maybe for aircraft companies or airliners. I think this happens around the world. There might be some promotional activities for the maiden voyage of an aircraft. It might take 2 or 3 days for a return trip, and there was no fun. I also participated in some of these activities. They are of a promotion. They are promotional in nature. You didn't even have the chance to wash your face before you were required to attend a briefing session. So I think we should not define whether it is a lavish trip just by the type of transport we use, whether it's a bus or an aircraft. It depends on the nature of visits. If we set the rules too rigidly, I think there will be problems with vetting applications. And if we just look at the money involved and decide whether it's lavish or extravagant or not, the criticisms may not be fair. So the most important thing is whether we can account to the public and to account to ourselves, and whether what we do is conducive to the business of this council. And I think we should let members some room to make their own subjective judgments. We also have members or non-members of this committee attending this meeting, and we welcome your views. Dr. Kenneth Chan. Thank you, Chairman. I am not a member of this committee. I think it's been 20 years since the Western countries started debating on this item, on accepting hospitality by offered by tycoons or those with powers. The public does have great concerns, and there are media reports that the government or the parliament members should review the mechanism. And now it's said that we do have this mechanism. The question is how the public perceives it, and whether we should be whiter than white. And in fact, the mechanism is clearly written in black and white. And I can give you some I can share with you my thoughts. I think it's not just about accounting to the public by a single member. If one member is being called into question, then the whole council would be called into question. This is not just the affair of a single member. It affects the image of the whole council. And secondly, as pointed out by some members, there is a point on whether the visit has any direct relevance with the duties of a member. And when you're required to give your explanation, this might be the most crucial thing. When you go on a visit, well, perhaps the briefing session was given, which might be relevant to the duties of the council member. And if the spouse or the relative of the member went along, then the member would become even more suspicious. So we should review the past experience on duty visits or acceptance of hospitality. And I think that the mechanism is an established practice, and it should be written out very clearly for members' reference. As for the acceptance of hospitality, it depends on the itinerary. It can't be said whether a 2-day trip is more harsh than a 4-day trip, etc. And I don't think we should dwell into these details, because these matters are relative. And I'd like to thank the LegCo Secretariat for preparing the information note. Although the purpose of visit includes the meaning of reasons for the visit, but some members might not be very clear about the reasons for visit. The purpose of visit, well, you can copy that from the information provided by the organizer. But perhaps if you also state the reasons for the accepting the invitation, it might help the public understand the reasons behind. So in this regard, we can draw reference from the practice for other bodies and state the reasons as well.
Mr. Yu. Well, the form, it says purpose of visit and name of sponsor. Those are not two separate items. I see a problem with the form. So that's why when you fill in the form, there's a gray area. I agree with Dr. Kenneth Chen on this issue. We have to be more specific, so there's no need to speculate or guess. Mr. Frankie Yuk? Well, thank you, Mr. Chairman. Many members have spoken. I agree we shouldn't decide by a particular amount. And I don't agree we need to have a vetting committee like what the state does. There could be a lot of arguments. You might say it's necessary. They may say it's not necessary. It's the same with private company. I can't just buy a ticket anytime and fly off. I have to apply with the company, and I have to give a reason why I need to make that trip. I agree we could include the reason, and the public could judge. So you have to give the purpose, you have to explain why you think you ought to go on that trip. Because even if you don't say so before the trip, you will have to explain yourselves after the trip. So I agree with Dr. LEUNG. We have to be accountable to the public, and so we have to leave it to members whether it's reasonable. But I don't agree we should have some sort of a vetting body. Okay, I've heard members' views. Let's have a focused discussion. Let me recap. First point, that is, we won't go the American way. That is, the American way is that you need the approval of a committee. No, we will just do what we're doing now. You know, the UK, Canada, Australia, and New Zealand, they rely on the public to monitor members. So we do everything out in the open. We're doing it already, but whether it's sufficient or not, maybe as Mr. Yu Si-wing mentioned, it's about presentation, whether we should include more details. So I think as a broad principle, that's the first point. That's what I heard from members. The second point, overseas visits. There are two levels. We have to get that right. One is duty visit. That is in the name of LegCo. Then now we have to first seek approval from the relevant panel, and there has to be a decision from the host committee. So its duty visit is clear-cut, and there's no case of spouses tagging along. It's never happened. So those are duty visits. Every term of LegCo, there is a provision for members, $50,000 or so. I couldn't remember the exact amount. Now, I have to say that, because here we talk about overseas visits, so that's duty visit. But, of course, there's another kind of visit, which is not duty visit. There may be organizations or individuals inviting us on visits, and those are what we call overseas visits. Like in this case, there's an airliner sponsoring the visit. And so that's the kind of overseas visit we're talking about in relation to that incident. Now it's a case of whether there is need for approval, because here maybe we have to consider whether it's overly generous or lavish. Some may say we have to travel economy, so it's not extravagant. Doesn't matter if it's 17 hours, 20 hours, or 3 hours for the flight. I think then maybe it's a matter of judgment for individuals. And the other issue is the kind of hospitality extended. And some may believe in this case it's generous hospitality. I think on this such a matter, members may have different views. Now, because these are invitations extended to members, some members have suggested spouses should not be allowed to tag along. But who should decide? Because the invitation may be extended to family members too. Is it for us? Or do we have the right to stop people from going to the visit? Of course, that's purely to do with members. There's no need to discuss it. But if others extend the invitation, and can we stop people from bringing their spouses? Do we have sort of penalty system or sanction system? Or if we go back to the basic principle, that is, we leave it to the public to monitor members, and everything is out in the open, and then members of the public could see whether there's any hidden conflict of interest in the business of the council. So that's another issue at a different level. And one other issue is about the details of declaration or registration. How do we improve upon that? I think we need to have discussion on these several points before we could decide on what we want to do. So on what I just said, what do you think, members? Ms. Shen Yin Han, Dr. Kenneth LEUNG, and Ms. Emily LAU, and then Dr. Kenneth Chen. Mr. Chairman, I think we ought to be strict with ourselves. Even if the other party says, "Oh, we'll invite your wife or parents along," we have to be clear that such visits are made because of our what we need to do for our work. So we shouldn't accept invitation for spouses and whatever. And then the declaration ought to be made more specific too. The purpose, purpose of visit, and so I think we have to be more specific so people can tell when they read it. The third point, I was just talking to Dr. Kenneth Chen. I asked him whether it works. Now, if there is a system in LegCo, I never talked to any friends, actually, it's just off the cuff. I'm saying this. Maybe for the media, they think it's right that we ought to be held accountable because they monitor us. Let's say every month we publish the invitations we accepted every month. Everything is on the internet. Yes, I know that everything is on the website, but can we take a certain action every month? Because right now, that last case really hurt us. So shouldn't we do some remedy from the PR angle? Yes, of course, we know everything is on the internet. But can we have a system to make public announcement on a monthly basis? Then the public may be happy with that. Because after the incident, people said, well, you people criticize government officials as you wish, but then you are so liberal with yourselves. And so we gave a really poor impression. Some other members said they were invited, but they just didn't accept the invitation. I was invited too. I didn't take the invitation. And I wouldn't say whether such kind of exchanges are good or not. But politically, of course, there are various motives. So we need to be strict. We need to be specific. We need to take some action so people see we are being transparent. I think that's important. Ms. Chen Yin Han. You know, even when they're overseas visits, maybe it's not like that case that the airliner invited so many. Maybe say, Dr. Kenneth Chan, you're a scholar, so someone invited you to go and give us a talk somewhere. So under the current system, you have to declare. But can we stop you from going? No. We don't have the right to do so. Maybe he wants to bring along his wife. But maybe you will turn down the invitation, but then others may receive such invitation. How can we stop people from accepting such invitation? Now, what I said just now didn't cover this point here, but I'd like to stress this. Now, when people invite LegCo members to bring along their spouses, yes, they can bring their spouses, but they must pay for their spouses. I think we should do that. I don't know if members agree. Well, we had a discussion among some members. Now, people invited us because we're LegCo members, and they invite spouses is probably a matter of courtesy. But personally, I would say we have to be careful. We mustn't give people the impression that because we are LegCo members, we enjoy certain privileges. I don't think it's right. You know, it's bad to project such an image. So that's just my personal view. Dr. Kenneth Chan. Well, let's take Kenneth Chan as Dr. Kenneth Chan as an example. He's a scholar. He's also a member. Maybe an educational institution invites him to go on an overseas visit. Of course, he's going as a scholar. But then to the public, you know, they see him both as a scholar and a LegCo member. And under the circumstance, I think the declaration ought to be stringent, not liberal. Okay, he's going as a scholar, but at the same time he's a LegCo member, so he should declare. And the second point about the declaration now is to make a declaration within 14 days. I think there's a problem with the time frame. Maybe we can say that before you depart, you should give details of your visit, the date, the destination, the purpose, the name of sponsors, and so on. You should give all such information before departure. And the Cathay Pacific incident, I received over 100 emails myself. I think the strongest reaction was that if it was not duty, it was not related to duty, how come your spouses went along? What's the purpose of your spouses going along? Maybe it's a matter of courtesy that the organization invited your wife or your family member as well. But I think about this family member, I think we should pay for our own family members. Of course, you can't force your family members to pay for themselves. Okay, if they've accepted the invitation, they want to go, but then I think the member himself will have to pay for his family member, just to put minds of the public at ease. Ms. Emily LAU? Sorry, I have to dash to another meeting, so my apology, Mr. Chairman. I follow what members think, but at the same time, I hope members understand what the public think. What the members did this time is done in the past. In the first, second, third terms of LegCo, members went on trips. Some even traveled first class. There was never a problem. It's just because there were now problems with some officials, and ICC is still doing investigation, and so there's a lot of controversy. And as I said before, we don't mind you chairing the meeting, but I hope members understand that the public have their views, but maybe the public see also members have the different views. I'm sure this won't be the last time we discuss the issue, but what I was saying earlier was that it's really about whether it's overly generous. That's what the public thought as well. Now, in the Democratic Party's guideline, we made that clear. You know, overly generous or frequent hospitality, we shouldn't accept it. But then other members or other political parties may have different views. But at the end, it's a collective decision on how we word the guidelines. So, of course, we will have to have discussion first. But especially when we talk about invitation from commercial companies, or is an invitation from other governments or from academic institutions, that's fine. But here we're talking about a commercial company, is a private visit, and there are family members involved. If you ask me personally, I don't think they should go on the trip. Anyway, the Democratic Party is also reviewing our rules. But of course, we respect the majority wish of members. If at the end members think we need not change anything, fine. But even if we don't change anything, you know, in this council, political parties could form their own rules. Perhaps the individual political parties may ban their members from accepting such invitation. Well, this time we had this incident. Well, it's because first last year there were some incidents involving officials. Some might say he just rode on a private yacht. Still, there was so much noise from national members. But here we're talking about a private company. Okay. I'm sure even if we say members are allowed to go on such visits, I'm sure very few companies would dare to invite us again.
So, Dr. Kenneth Chen, I have several observations to make. The party making the invitation could be other government organization or quasi-government organization or even a private organization. I don't think it's very important who is making this invitation. Sometimes a government or quasi-government organization can also spark controversies. Some large organizations might be perceived by the public to be corrupt, etc. That's not important. The important thing is us as members. I'd like to thank members for paying attention to my role as a scholar as well. I never had the opportunity to explain to members of the public whether I am acting in the capacity of a scholar or a electoral member or in my personal capacity. We need to understand that the public doesn't perceive the matter this way. Even if we're wearing different hats, we need to remind ourselves that the public sees us as a public figure. They see us as an electoral member. So we really need to state the reasons of the visit, and it has to do with our official duties. We need to explain this clearly. And as for family members, well, we need to clarify this is problematic because the public might think that we are getting some kind of benefits. So if our family members also accept the invitation, then we need to be careful whether we should pay for the expenses. As for myself, as a public, as someone with public duties, I can give a full account of the purpose of visit, etc. As for the family members, it's best that the expenses are borne by members themselves so as to address the concerns of the public. Mr. Yu Si-wing. First of all, I think the public has the right to know. The public should know what you are doing, and there should be a clear account. And as electoral members, you should also make your own judgment. You should consider whether the reasons so stated would be accepted by the public. If you make a poor judgment in this regard, then you might be questioned whether you should be a member. Whether you want to bring along your spouse or your family member or not, as long as you think that it is justified, you can state the reasons. You might think that there is a reason why your family should go along. Maybe the other party would like to meet your family members as well. Just state the reasons. Because if you put down purpose, if you put down study tour as the purpose of visit, then that can pass. But a study tour cannot be made a reason of the visit. So for other matters like the money, the amount of money, I don't think these are important. As for 14 days after the trip, I agree with Dr. Kenneth LEUNG that declaration should be made before departure, because you also know about the trip well in advance. So let's simplify matters, declare before departure, and separate reasons from purpose of visit. Now it's put under the same column, purpose of visit together with name of sponsors. So it seems that you can muddle through by doing so. So to meet public expectations, we should make the form more clear, so that when an incident arises, the public can inspect the information, and then they can decide whether to accept your explanation or not, whether it's a matter of your poor judgment, or whether there is a wrong information provided. You bear your own consequence. Any other comments? If not, then I'd like to say something about the period for making declaration. Now it's 14 days after the trip. It seems that it seems that members agree that we can actually make the declaration before departure. I don't see a problem here, legal advisor. If you see a problem, please raise your point. It's a matter of changing the mechanism. Perhaps I myself don't find a difference whether we declare before or after the trip, but if it can reassure the public, we can do it before departure. The other point is about relatives. We are under public scrutiny, and under the existing mechanism, we can there is no way for us to stop members from doing so, but we can give advice or perhaps remind members to consider this issue himself. If there is an invitation for a duty visit, and if you're going for overseas visit, and if you're going in the capacity of a member, and if your family member goes along, then please pay for the expenses yourself. But we cannot stop the member. In the U.S., the mechanism is that the member would need to bear all the relevant expenses if no pre-approval has been given. What about spouses? In the U.S., if the member goes in the capacity of a member, then he can bring along one family member. So even in the United States, one relative member will be allowed. So should we maintain status quo? Should we adopt the UK or Canada system and only give advice or reminders to members? SG, I'd like to make a point. This is a register of members' interest for public inspection. For overseas visits by members in the company of their spouse, it's not a question of whether we approve or disapprove, of we permit or we don't permit. It's a question of whether if the member has received hospitality, then it should be disclosed. So that's in relation to the period of declaration and the wording in the registration form. Then according to the paper that we discussed in the previous item, we can improve the form by reviewing the mechanism. Thank you, SG. The focus of today's discussion is that many members might think that the spouses of members should not accept the invitation. I think from what I hear, this seems to be the more problematic. And I think we should leave it to members and the public to discuss the matter, because this is about the register of members' interest for public's inspection. There is no question on whether we should permit or approve the visit or not. And when we review the registration form, perhaps you can include this question in your questionnaire and seek members' views. When we come to a conclusion, we can then decide on the wording to be used in the form. Dr. Kenneth Leung, Chairman, I think, yes, this is the direction that we should be heading. But family members is a key point in the public's discussion. They queried why the spouse of the member would go along the trip. We cannot ignore the public's perception. This is one of the major criticisms from the emails I received. As for lavish or extravagant or overly generous hospitality, I think for members present here, including myself, we have different and diverse views on this matter. For those traveling business class, if this is regarded as extravagant, I think in many other countries, they might perceive it differently. So one thing is clear. We are not going to set a standard or set a criterion on what is meant by extravagant, what is meant by overly generous. From what I understand, Ms. Emily LAU and Ms. Chen Yunhan were both saying that we should make our own judgment and be accountable to the public. Is that how we should handle it? We shouldn't define extravagant or generous as, say, $1 million or $1,000. Members, your views? I think we will agree because we have different definitions of extravagance. And when we accept the invitation, when we fill in the form, regarding the reasons of visit, maybe it's very clear it's for sightseeing or for checking out the traveling routes, and we're passive about the itineraries or the arrangements. We have no say in the arrangements. So we must not set a standard for extravagance. Our voters will judge whether this is a reasonable arrangement or not, as long as we set out all the details. Dr. Kenneth Leung, well, some members of the public asked me via email whether it's extravagant to travel business class. Actually, when I am on a business trip, very often I don't. I travel something better than a business class, and as for whether I should provide detailed itinerary and the destinations, etc., in the form, whether this will provide more information to the public and let members consider whether he's doing something extra, and by filling in the form, the member can then rethink whether it is appropriate. For example, it's just a one-day business trip followed by 2 days entertainment at the destination. So you mean when making the declaration, the itinerary should also be declared? So it seems we don't have a consensus here. The U.S. mechanism is quite interesting. They stipulate that first-class transportation is not allowed. Can this serve as our reference? Well, in the U.S., under the U.S. mechanism, in the application form, the itinerary should be provided, including the conference to be attended. SG, I'd like to clarify one point. To my understanding, there is a consensus among members that we should follow the mechanism of disclosure or a register of interest. This is obviously different from the approval mechanism adopted in the United States. One is based on registration, one is based on approval. Chairman, you also mentioned just now whether the spouse should come along or a family member should come along, then our requirement here is actually strict. You are required to register if your spouse or your family member is also attending that event. Chairman, is it the case that you like to include this question in the questionnaire? That is whether the spouse should go along. So I'd like to clarify one point, whether we would like to stick to the registration arrangement or disclosure arrangement or not. So is it that we need to ask members what should be registered, or whether we should review if anything should be subject to regulation? I think it should be disclosure based. We're not trying to regulate, but there are controversies over the spouse and family members, and would like to seek members' views on whether a reminder should be given. It should not be made a regulation, and I'd like to hear from members. There is no way we can disapprove the trip. The whole matter hinges on monitoring by the public. There is no question on whether we approve or disapprove the trip. Dr. Kenneth Chan.
I don't think we're not talking about whether we should have said of regulatory practices. With that disclosure, I think there's no problem with that. It's just a matter of how we improve upon it so that we could give more information to the public. But here, when we talk about regulatory practices, we're talking about self-discipline mostly, really. It's not that there should be a committee to regulate what we do. I think we ought to give a reminder to members that when they accept such invitations in the future, and if spouses are invited, they have to consider the perception to the public. So we should put that in writing for members' reminder, and then it will help the member to decide whether to accept the invitation. I wouldn't say it's a rigid requirement whether they should they are allowed or not allowed to accept, but rather we should remind members that it's a matter of perception to the public. It's about public monitoring. So next time when members receive such invitations, they will think it through carefully. And if they do accept the invitations, they have to consider how they might explain it to the public. Maybe I have to attend a particular function. Maybe I have to accept the visit. Or maybe I need to bring along a family member to take care of me or whatever. So you have to just explain it. So that's where we need to remind members. That's what I'm talking about. SG? If I may add, Mr. Chairman, if that's what the member meant, now we have a series of advisory guidelines published by this committee, and we could perhaps improve upon the content about family members' involvement in overseas visits. Dr. Kenneth Leung. Well, another point, apart from family members, if we advise members to do how to do certain things, or whether it's regulatory advisory, some members might say, well, since I'm there, I might as well stay another couple of days or whatever. I think all such reminders ought to be included in the document. So when we are invited on overseas visits, members have to think through all the relevant factors before deciding to accept the invitation or not. And of course, then they must register the interest as well. So it's some form of ethics guideline. Or I don't think it needs to be something like an ethics guideline, but perhaps advisory guidelines, as the SG pointed out. SG? What Dr. Kenneth Chen or Kenneth Leung said, and you've also heard from the SG. Do you agree this is the appropriate way to go about it? Personally, I think so. As we remind members to consider all these factors in deciding to accept the invitation or not. But it doesn't mean we will prohibit members from doing so. Okay, anything else, members, on this point? I think we've... I could only extend the meeting to 6:45 at most. If there is no other point, then we can wrap up the discussion. I don't need to extend the meeting. Okay, then. Now, perhaps we'll improve upon the declaration system on the basis of our discussion today, okay? And on the advice of the Secretary. Okay, that's all for this item. Anything else? Under AOB? Nothing under AOB, so meeting is adjourned. Thank you.